So welcome everybody today to our Suffolk County Collaborative Circle. We're going to be talking today about job loss. And job loss during any time is very significant, and it can be very painstaking for any family. But during the time of COVID, it's really hit families in a different way, in a bigger way. And certainly families who are going through divorce or separation, they've seen it, the struggles even more. So I'm honored today to be joined by my colleague, Deborah Rubin, who is also part of the Long Island Collaborative Divorce Professionals. We're going to be talking today about job loss in general when you're going through divorce or separation, and again, specifically during times of COVID, right? So job loss in general is not something that anyone is really immune from, right? From the local union worker to celebrities, right? We've heard about celebrities like Roseanne Barr or Nick Cannon or Charlie Sheen. They've lost their jobs due to, for many different reasons, not necessarily due to COVID. But while nobody here is probably crying for celebrities who are losing a multi-million-dollar contract, that loss in revenue and income is real, right? Whether it's that you're earning $50,000 a year or you're earning $50 million. So when you're relying on that income and now you don't have it, this is something that we really need to take into consideration for people when they're going forward. So whether we're talking about maintenance or child support, or maybe even just debt allocation, paying back debt. Again, these are things that we need to consider and see how it is that we can structure a way for families to go forward. So again, I'm joined by Deb Rubin, who has been a fantastic member and collaborative attorney through the Long Island Collaborative Divorce Professionals. She's also a really fantastic and experienced litigator here in New York. So I really welcome your expertise and your insight into how it is that you think that the courts now are handling job loss, whether it's due to COVID or pre-COVID. What are your thoughts on that?
Well, historically, it's very common during a divorce proceeding for one spouse to all of a sudden claim a decrease in income, whether that's due to a job loss or for some other reason. And in the past, courts have generally looked at that with a degree of skepticism. And there's this catchphrase called the sudden acquired income deficiency syndrome of the moneyed spouse that commonly befalls them during a divorce proceeding. The courts now are giving more credence to such claims of decrease in income, whether that be due for a business owner due to a decrease in revenue, or whether that be to an employee who's been laid off from his job due to COVID. The courts are in effect taking judicial recognition of the fact that there's really been a global impact on the economy, and is giving the moneyed spouse more of the benefit of the doubt if he or she is making such a claim.
So now, are the courts, in your experience, again, because this is still very new, but in your experience, are they asking specifically if that job loss is due to COVID? Do they need proof of that? How is that working right now?
Well, I would like to say, and this is one of the reasons why collaborative is so great, I would like to say that there's a degree of consistency in this regard when you go to court, but every judge is a human being and they all have their own preconceptions. So you're not necessarily going to get the same input from Judge A as you're going to get from Judge B. From a legal standpoint, the standards to seek a modification of your support obligation due to a decrease in income are unchanged. And what that means from a legal standpoint, if you have an obligation to pay child support, you're supposed to show that there's been a substantial change in circumstances, and you're supposed to demonstrate that to the court. If you're looking for downward modification of your maintenance obligation, you're supposed to show that you're suffering extreme hardship if that maintenance obligation was made pursuant to an agreement. So that's an even higher standard to meet. What the courts are supposed to look at when you're looking to meet that obligation, number one, did you lose your job, or was your income decreased through no fault of your own? And have you made efforts to find employment commensurate with your prior earnings? So that's the type of proof that's supposed to be provided to the court in any situation where somebody's looking to reduce their financial obligations due to a decrease in income, whether because of COVID or some other reason.
Yeah. And I feel like that to be able to prove that you're seeking other employment that might be equivalent to what you have now, sometimes it's hard depending on the industry that you're in, right? And
Correct.
you know,
Correct.
yes, certain industries are getting hit harder than others, right? So if you're in the restaurant industry, are you necessarily going to be able to seek employment that is similar? You know, you might not be able to because there's no job opportunities out there.
You're a gym owner. I happen to have a case now where there's a gym owner involved. I mean, those are things that, you know, you don't really have to show much to the court because they know what's going on up there. It's all over the news. It's, you know, not a surprise to anybody. But there really is an obligation, you know, and it depends how things play out in the short term. But if these industries don't get back on their feet, there's an obligation on the part of a parent or a spouse to look for other work. And it might not be as lucrative. And in that case, the court may lower the support obligation if they see that diligent efforts have been made, but there's an inability to continue to earn income at the prior level.
Right. Yeah. So, I mean, it is good to see that the courts are recognizing this and they're more aware of it. But if we were to compare the court system in general, right, again, dealing with job loss, compared to if we were to be approaching this, either a divorce or a separation in a collaborative model, what do you think would be some of the main differences in how we could approach it regarding either the maintenance obligations or, again, paying off debt, those kind of things when it comes to job loss?
Well, the great thing about the collaborative model is that you go in there with the goal of being cooperative with each other, and you're trying to foresee the problems that could arise down the road and plan for them. By going through with the collaborative model, you're saying, we don't want to go to court. We don't want to go to court now. We don't want to go to court somewhere down the road. So we want to deal with those problems now. So you can address in the agreement what happens if Mr. or Mrs. X loses his job somewhere down the road. What happens if Mr. or Mrs. X retires? Under what circumstances are we going to allow a reduction in the support obligation? It's also possible to provide X number of dollars for support during this period of time, Y number of dollars for support during that period of time. Or if there's a concern that a party's going to lose a job, you can be creative and, you know, perhaps say, look, I'm going to pay you an extra lump sum up front because I might not have this money down the road to be able to meet my obligations. So there are all kinds of creative solutions that you can come up with if the parties are working towards the same goal.
Yeah, and I love the flexibility, right? Just all those different scenarios you came up with right there are things that at least I don't see addressed in court, right? The court system in general has a very rigid structure about how they do things, which is just traditionally the way things have been done. But all those different scenarios you just came up with are really things that could be tailored to each family, you know, to each unique needs.
The court's not going to be creative like that for you. The court has certain parameters that they're going to work within. Either I'm granting your application to reduce your child support obligation or I'm not. There's not going to be some kind of compromise in between that you're going to get if you go to hearing and have a judge decide.
So in your experience, when we have anything like this, like a job loss or even job interruption, you know, sometimes there are times when a contract is not renewed, but it might be in a few months. So for those type of situations in a collaborative setting, do you find that it's the attorneys or maybe the financial neutrals who come up with these different scenarios or ideas, or do you think it's the parties?
I think it's a combination of everybody. I think it's a combination of the efforts of all. I mean, the attorneys can give the parameters by telling the parties what's likely to happen in court. The financial professional is able to sit there and crunch numbers with them and say, look, this is how this is going to work out for you in this scenario, and this is how this will work out for you in this scenario, to kind of get them past the unknown, which creates a level of discomfort for everybody. Well, what's going to happen to me in 2 years? You know, you want to try and get them past that as best as you can. You can't always anticipate every scenario, but there's much more of an opportunity to be creative in the collaborative context and come up with as many possible different scenarios and solutions as possible.
Yeah, and I love that, relying on the expertise, right? Let the financial people crunch the numbers, let us throw some ideas out there, and then we all come to a resolution that works better for them. Yeah. So thank you so much, Deb, for joining us, and thank you for your insight as to the differences between litigation model and collaborative, especially when it comes to job loss or job interruption. And I welcome any of your closing remarks, but I just, again, want to tell you how honored I am to work in this field with you, whether it be through litigation or collaborative. You always have the ability to see things differently and the insight to try to help families move forward, which is really what it is that we're trying to do here through the Long Island Collaborative Divorce Professionals. So any closing remarks that you have, Deb?
I just want to thank you for the opportunity to speak on this subject. And I also want to encourage anybody out there who may be going through the divorce process to seriously consider the collaborative model. It avoids a lot of problems that you have to deal with in litigation. It helps the two of you work together to reach a solution that's better for your family, as opposed to just having it dictated to you in the court. And it's just a wonderful process in the right case. So I urge you to look into it and give it serious consideration.
Yeah, I echo everything you just said, right? And echoing back to what you said at the beginning, right? That there are so many different ideas and scenarios that we can lay out for you in ways that you might not be able to have the opportunity to do in court. So again, if your family is thinking about or in the process of separation or divorce, we certainly encourage you to find out more about it, find a professional in your area, certainly look at our website, LICDP.com. Reach out to any of our professionals on that website. They will all give you a free consultation about the process and how collaborative works, give you a little bit more insight into that. And again, we thank you for joining us today, and we hope you found this information helpful. And we look forward to seeing you next month at the next Collaborative Circle. Take care.